All right. Good morning, good morning, good morning. It is Monday, January 9th, and we are into our 2023 year for these sessions. As a matter of administration, I would tell you that I'm actually very excited for these sessions. We have a couple of really good ones that are actually scheduled for the next several weeks. In 2 weeks' time, I'll be speaking with Dan Falk, for those of you who know him, and Ron Butler, and we're going to be doing our 2023 crystal ball, what portends for the industry. If you know Dan, if you know Ron, they're some of the best and most serious voices who can project where we're going to be. And then following that, we're going to revert back to our legal schedules. And one of the things that has been asked for, which we've managed to assemble, is going to be something on the law of privacy as it relates to real estate, video sessions, and the like, and recordings. A lot of people have a lot of questions about that, so we're going to be going there. And then we have a bunch, we also have Alex Melfi, who's going to be making a return. He's the one who sued the title insurers and did a whole title insurance presentation for a long time. With us. He's actually going to be answering questions about co-ownerships and how to structure agreements for agents. And we have a whole range of other ones that I could talk about, but basically we're going to try to hit them out of the park every 2 to 3 weeks. So Brian is going to be the first in many esteemed discussions this year. As a matter of course, administratively, everything that is said on these videos is public, even though our forum is private. Be aware of that. Any questions are recorded and placed on multiple forums. Speaking of multiple forums, it occurred to me that many of you aren't aware that we own a YouTube channel, and all of these previous sessions are on our YouTube channel, available to anyone, including Brian's previous sessions on deposits and others, which are very worthwhile checking out. The YouTube link can be found at the top of our announcement page in our forum. I would encourage you all to check it out. And as a final note, before I make my introduction to Brian, which will be 30 seconds, we are now at 11,000. So we're now on the way to 20 people. We're on the way to 20. The goal is to hit 20,000 people and members by the end of this year. Let's see if we can do it. Congratulations to all. Thank you. Let's keep building a wonderful, embracing community that we can all learn from and enjoy. All right, so Brian, I'm not sure I really need to introduce Brian. I feel like when you just put up a picture of Brian Madigan, every one of us absolutely understands who we're dealing with and why we're here. There's a reason that there's 150 people in before we have even, and climbing before 10:05. And that's because Brian is really one of our thought leaders in the industry. Brian is someone who not only has the ability to digest changes and understand the law, but he possesses that unique skill of being able to describe it clearly, accurately, and makes a lot of sense for those of us in the field. Brian is an invaluable resource, and I would tell you that Brian does these sessions on a complimentary basis. But if you like what you hear here today, Brian also runs sessions for realtors throughout the years. These are sessions probably exclusive amongst other sections that our group strongly recommends that you attend. It makes you a better practitioner. And frankly, things that come out of Brian's mouth are usually there simply because they're the important stuff that you need to know as a practicing realtor. So without further ado, I'm done talking. Brian, I'm going to turn it over to you. You're going to talk about the developments and changes to the code. We're looking forward to it. And I think Brian's planning on doing less than an hour of talk, and then I will open it up for questions and we'll go from there. Thank you again, Brian, for today's attendance. And I'm going to go mute. It's over to you.
Okay, thank you very much. And congratulations on this forum. Mark, you've done an absolutely excellent presentation in terms of having this forum that works, keeping it organized, keeping it
not just me, Brian. It's not just me. There's a lot of people in the background working very hard. So some of whom are here today.
Well, it was your idea. So we'll leave that. It's something that I could certainly not do at all under any circumstances. Completely beyond my level of expertise and competence to run something like this. In any event, let's talk about the new code of ethics. Now, that's going to be the basis of your liability going forward, and that's going to come into force very, very quickly. So the first thing is what you should do sometime today is look at a copy of the new Code of Ethics and read through it. And to a certain extent, that's really what we're going to focus on today, is just going through this new Code of Ethics and to have a little bit of background to help you read it and understand it. And that's really the focus of what we're doing today. Of course, there aren't any cases. We've got to wait until there's some new interpretations with respect to that. So first of all, we have to have complaints. They have to go to RICO. Then they have to be adjudicated and published. So that could easily be a year. Same thing with respect to any civil liability. We'd also have to have that. So you can appreciate that we're not going to have any answers to the questions that you might pose for perhaps 18 to 24 months. So in the meantime, it's your best guess as to what this new Code of Ethics really means. Now, one thing just to be aware of is that the Code of Ethics, if you've read it already, you will appreciate that it's very short, very, very short. And the concept, this, at least with respect to those who drafted it, was to come up with a Code of Ethics. And you'll recall that the existing Code of Ethics deals with a whole host of other issues in addition to what might be considered ethical practice. So they've done away with all of that. Now it's not gone. It's just they have not carried that forward into the existing brand new Code of Ethics. So it isn't necessarily gone, but I want you to appreciate that there will be some changes that you'll see. So some things are gone, some things have been restated and will be found elsewhere and no longer in the Code of Ethics. So I want you to be aware of that sort of body or context. So let me share the screen here. And we will. Okay, I think before I did that, I've made a little error here. So I've got to. Now, hopefully everyone can see that.
Yes, we see it.
Yeah, okay, perfect, excellent. So what we're talking about now is the new Code of Ethics. And when does it come in? Well, basically, it's going to come into play the 1st of April, 2023. So that's coming up pretty soon. So what it does is it focuses on ethics and related issues. And there's some other administrative provisions that are no longer part of the code. They're not necessarily gone forever, but they're not part of the code anymore. Now, one of the major things that we have to look at is the whole concept of customers. That's gone, doesn't exist anymore. We're done with that. What we have is 3 categories: clients, okay, self-represented parties, and consumers. That is just somebody who's a member of the public. And there are duties that we owe to each of those different classifications. The whole concept of customers came in the early 1990s. It was an invention of the National Association of Realtors in the States. And they came up with the concept of customers so that a brokerage would be able to double end a transaction. In other words, it could act for the buyer and the seller in the same transaction. And so that was fine. They seemed to deal with that. But certainly the whole issue of customers was a lower class in some way. And it was very, very sophisticated to try and understand where they were. Now, they paid the same price as everybody else. It wasn't a question of, oh, well, I want to be a customer because I'm getting a deep discount. No, you're paying the same price, but you're sitting in steerage class, and you may not necessarily appreciate that. In any event, that's gone. So now we have a question of the new code coming in. The question, of course, is what code is actually going to apply? So if we look up to the end of March of 2023, it's going to be the old code because the new code isn't in yet. Then we go to March 31st, and the next day we have the new code applying. And now, assuming that everything just started April 1st, it's the new code that's actually applying. But in most of the transactions that you'll probably have in 2023, you're going to have both codes. So the old code applies with respect to what you're doing now. The new code applies with respect to that part of the transaction that takes place starting April the 1st. And so you could have both of them working for you. It isn't a question of just one coming in and one disappearing all instantly at the same time. No, it's you're going to have transactions where both are in place. Now, customers, you can sign up a customer now and probably have them continue. And I think I did the math on this. It's kind of 60 days after the new code comes into force. So you're going to be looking at sometime maybe in July to have that expire completely. Now, there's a couple of different divisions in terms of the new code of ethics. First, there's a division and it just deals with integrity, integrity alone. And then the next one is conscientious, competent, and quality service. Next issue is conflicts of interest. And finally, they deal with the issue of other relationships. So in terms of the code of ethics, these are the four categories that they're going to look at, focus upon, and have in place. And if you're looking up the new code, it'll be Regulation 365 of 22. Now, there's some basic fundamental qualities that you kind of need to understand, and it's probably well worth memorizing this particular page. Courtesy, honesty, good faith, and integrity. What are they? Courtesy, honesty, good faith, and integrity. Say it again. Courtesy, honesty, good faith, and integrity. And it would be very, very helpful for you to be in a position where you knew and you could respond to that if you were ever in the witness box in a trial or any other legal proceeding, where if you were asked something about the code of ethics, that you're able to emphasize courtesy, honesty, good faith, and integrity, as opposed to, oh gosh, I have no idea. Oh, I haven't looked that up for quite some time. No, that you're able to recite it and you can come up with it virtually instantly. Now, the new one in here is courtesy. That's kind of a little bit odd. I don't know. Maybe it's just politeness. Maybe it's a Canadian thing. I don't know, but you're asked to be nice. And so being nice is part of the ethical obligations at this point in time. Now, we're going to go to another couple of things, and that is the legal issues of honesty, good faith, and omissions with respect to things that you may have done or in effect not done at all. So when we look at the question of honesty, these are three cases that are in the Supreme Court of Canada. Mason and Friedman was in 1958, and it dealt with the issue of honesty. Basson and Renew was relatively recent. That was 2014, and it dealt with the question of good faith. And we had another case, Callow and Zollinger, in 2020, and it looked at all the cases refer to one another, or at least in series as they were announced. But you'll see that what we have here is the Supreme Court of Canada dealing with different issues. There's an expectation of honesty. There is an expectation of good faith. And more recently, in terms of the Callow and Zollinger case, you've got to speak up. It's not a question of just going silent. It used to be, well, no, if you didn't say anything, you couldn't get yourself in trouble. Now, there's an obligation to speak up. Don't have someone believe something which isn't true. If reasonably speaking, you would think, you know what, I think it really is true and I should tell them. So there's an obligation to speak up. And it's not very old, it's 2020. So here we are going into 2023. And so that's a relatively recent case by the Supreme Court of Canada. And that is something which underlies your legal obligations. Now, where do we have the basis of liability? Well, there's two aspects of that. One is discipline. So these are RICO complaints. Someone's going to make a complaint about someone to RICO, and they'll deal with the question of discipline, and the ethical obligations under the Code of Ethics will be prominent. The other thing is that there's three categories of law in which an individual who is practicing in the real estate field can be found to be liable. Number one, contract law. Well, you know all about that. No question about it. Tort law, that's a little different. That is, there's no written contract of any nature, but it's the whole question of negligence and doing something that's wrong, which causes someone else some financial loss and damage, and they have a right to compensation. Usually that's based on a misrepresentation of some nature or kind. And then the third body of law is the law of restitution, and that's going to apply with respect to your relationship with your clients being agency. So that's going to be the compensation that's going to be available to them under the law of agency by reason of the fact that you have it's been alleged that you breached your fiduciary duties to your client. So those are the categories. Now, when we're looking at it, how important are these things? Is this just nonsense, or is this something which is incredibly important? Well, let's look at a case, Hodgkinson and Sims, Supreme Court of Canada. And basically what they said is, in sum, the rules set, and this was a case involving someone suing an accountant. And the accountant said, well, I may have offered some assistance, but I wasn't acting for you and I wasn't your agent. And the Supreme Court of Canada said, we think you were an agent. And then the question is, well, what did you do? What, if anything, did you actually do wrong? And what they decided to do is, let's pull out the ethical obligations and the rules of professional conduct that apply to accountants. Well, you know that they're going to do that with respect to every profession. Lawyers, pull out the list of ethical obligations. It can be doctors, and here we're talking about a situation where this can be real estate agents as well. So here's what they say. It's only a couple of paragraphs. In sum, the rules set by the relevant professional body are of guiding importance in determining the nature of the duties flowing from a particular professional relationship. And they go and quote a case McDonald and Martin from 1990. With respect to the accounting profession, the relevant rules and standards evinced a clear instruction that all real and apparent conflicts of interest be fully disclosed to clients, particularly in the area of tax-related investment advice. The basis of this requirement is the maintenance of the independence and honesty, which is the linchpin of the profession's credibility with the public. It would be surprising indeed if the courts held the professional advisor to a lower standard of responsibility than that deemed necessary by the self-regulating body of the profession itself. And so this case is Hodgkinson and Sims 1994. You can appreciate it's been around for a considerable period of time, and it's the law. This is actually the leading case on agency. So now we have some do's and don'ts when it comes to the Code of Ethics, and I've just rewritten the code. I've used their actual expressions line by line, word by word, but I put them in terms of a what should you be doing and what should you not be doing. So I've rephrased it something along those lines. So let's look at the first topic, and that's integrity. And here's the do's and don'ts. Do act with courtesy, honesty, good faith, and integrity in relation to every person. Those words, magic words, what are they again? Courtesy, honesty, good faith, and integrity. So that's something that if you're going to memorize anything, that's something that would be very worthwhile going forward. Number two, make best efforts to ensure that any representations are accurate and are not misleading. Now, the interesting thing there is that's a little bit more than simply saying it out loud and saying it out loud a second time. That is, make sure that your representations are not misleading. So this is going to involve speaking up and dealing with an omission that may be there. And so you're going to have to be critical of your own representations in that regard. Did I say everything I should have reasonably said? Now, don't engage in any act or omission that would be disgraceful, dishonorable, unprofessional, or unbecoming. And don't engage in any omission that would bring the sector into disrepute or undermine public confidence. So again, now we have two things that are omissions. And that's a little bit different. This is reflecting the new attitudes of the judicial system in terms of, maybe silence isn't golden anymore. You're going to have to speak up in terms of your own professional conduct. Now, again, still with respect to don'ts, and we're dealing with integrity, don't counsel, advise, or knowingly assist a person to contravene. Now, here's what the list is. The act, okay, so that's TRESA, the trust and real estate professions, and the regulations, being the regulations under TRESA, and any other law. Well, that's interesting. Any other law, that certainly includes statutory law and legislation, regulations under that legislation, and the common law. That's what it says. It doesn't restrict it in terms of any particular way. Engage in or be a party to fraud. Now, also remember that fraud has an expanded definition when it comes to civil liability, and that is, it's not simply something which is mischievous in terms of someone knowing that something is wrong and they say it incorrectly in order to induce you to do something. No, that's criminal fraud. Okay, civil fraud has an expanded definition, and that actually includes reckless and careless conduct, not caring whether a statement be true or false. So what that means is a fraudulent representation can involve something in which you, I don't know, I just said it, I'm sure it's true, it probably is. No, that's not good enough. Don't say anything and be in a position where we can have a false representation, and that could in fact amount to fraud. Now, don't engage in or be party to misrepresentation or any unethical practice. Don't treat any person in a manner that would contravene the Human Rights Code. And of course, that's new, that's brand new now, brought into this Code of Ethics. And don't engage in conduct that is intimidating, coercive, or abusive, or that constitutes undue pressure or harassment. Now, when it comes to interesting little nuance there, undue pressure. Well, very often there's all kinds of situations in which we do have undue pressure. yeah, go ahead and buy this or you're going to miss out. Accept this offer or you're going to be stuck with this property forever, et cetera, et cetera. And so there can be any number of different types of nuances that can amount to undue pressure. That's a new concept in terms of this particular code of ethics. Now, we're going to slide over one thing, and that is in terms of quality, do's and don'ts. What are you going to do? You're going to promote and protect the best interest of clients. Well, that's your fiduciary duty anyways. And so we've been following that all along, and that's not a question. Now, what you're going to also do is make reasonable efforts to ensure that the client understands the information and appreciates the reasonable, foreseeable consequences of their decision. Now, that's interesting. That's new. That is, we're bringing in this whole concept of informed consent. And while that sort of first came into fore in 1979, 1980, in terms of a case involving a doctor, Ribble and Hughes, and eventually went to the Supreme Court of Canada. Informed consent is something which has been around for a long period of time. And you would want to be aware of that. And now it's being indoctrinated right into the Code of Ethics itself. Now, when it comes to quality, do's and don'ts, do provide conscientious, courteous, and responsive service to clients. Okay. And you have to demonstrate, and this is for clients, reasonable knowledge, skill, judgment, and competence in providing service to clients. So that's basically what you're going to be tested upon. Again, so what is your measure in terms of what you're doing? You're going to have reasonable knowledge, skill, judgment, and competence, and going forward. And if you don't, that's going to be potentially an issue. Now, for any person, now this includes the public. Demonstrate, you're going to have to demonstrate reasonable knowledge, skill, judgment, and competence in providing opinions, advice, and assistance or information to any person. Well, that's interesting because we're now talking about information to any person. So that's anybody coming to an open house. You have no particular relationship with them at this point in time. And you might have thought, well, I can, I'm not going to be tested. I'm not going to be in a position where I'm going to be sued. But before you get along the lines of saying that the world's best school is 2 blocks away from that house where you're conducting an open house, maybe you should just rethink that and say, yeah, there is a school over here. And, the name is ABC Public School. Okay, yeah, good enough. That information is accurate. By the time you get into an assessment, that could be problematic going forward. Also, what you have to do is advise a person to obtain the services from another person if the registrant is not able to provide the services with reasonable knowledge, skill, judgment, and competence. So if you're being asked about a school, it's sort of like, you know what, you can ask me about the house, but now that we've moved off the topic of the house itself and the size of the lot and the swimming pool in the back, and you're now asking me about the school system, you better contact the school board. So that gets you off the hook. So what you want to do is be in a position where you can document that. For self-represented parties, what you don't want to do is provide services, opinions, or advice to a self-represented party. That's precluded. What you don't want to do is encourage a self-represented party to rely on the registrant's knowledge, skill, or judgment. So you're not trying to develop any degree of dependency in respect to your relationship with a self-represented party. And what you're going to find is that many people who previously might have been a customer have now slid over to this new category of being self-represented. And we're going to distinguish that where there's not going to be any advice basically at all. Again, in terms of quality section and don't discourage a person from seeking a particular kind of service from another person if the registrant lacks reasonable knowledge, skill, judgment, and competence. Again, reasonable knowledge, skill, judgment, and competence. If there's 4 additional expressions that you need, those are the ones. Disclose to a third party any confidential information of a client without the client's written consent. So now we're stepping it up. We have to have the client's written consent in that regard. So that doesn't mean that an email is going to work in that regard. What it means is you're going to have to get them to sign something. Give me permission going forward to release this particular information. And so you're going to have to go through that next step. In terms of conflicts of interest, that's another section. That's the 3rd section in the Code of Ethics. What you're going to do and don't, you're going in under the do category. In the case of a conflict of interest in advance, you're going to disclose to the client or prospective client any transaction or relationship that could reasonably be expected to give rise to a conflict of interest. So you're going to mention that, you're going to say that, you're going to have to come up with any number of different scenarios where you think I potentially have a little bit of a conflict of interest here. I've recommended this particular mortgage broker in the past. They've worked out to be successfully with me in transactions, but I need to mention the fact that they have in fact made some referrals to me. Oh, wow, geez, okay. Well, that's a little different. And a person can, would going forward think, well, that's fine. I can accept that. Advise the client or prospective client to seek independent professional advice. So again, that's what you would have to do. When it comes to conflicts of interest dues, take all reasonable steps to ensure that the client or prospective client has demonstrated a reasonable understanding of the potential conflict of interest. How do you do that? Well, you'd have to have them say it back to you where they appreciate it. All right. It's not a matter of you going one step. You've got to go 2 steps with this. You're going to have to make sure that they can explain it to you. That's a little different than what we've had in the past. Obtain the consent in writing from the client or prospective client to the provision of the registrant's services, despite the potential conflict of interest. All right. All of those words, they're all contained in the new Code of Ethics, so you have to be aware of them. Now, when it comes to don'ts and conflicts of interest, don't provide services, including representation to a client or continue to provide services to a client where the interests may conflict. So you're just going to have to say no. Here, I've got a situation. I'm going to refer you on. I'm going to move you on. I'm going to make recommendations that you obtain some professional advice and guidance going forward. So what we're going to find with the new Code of Ethics is that there's a lot of clients there who are going to be in transition. And so you should expand your list of professional references and be in a position where you have, in terms of most categories, 2 or 3 people that you can recommend, not just one single person. Now, when it comes to conflicts of interest, the new conflict of interest rules say first, don't act. Then if you do, disclose the conflict, recommend professional advice, ensure the client's informed consent, and document the client's decision. Now, if you're in front of RICO, and what are you going to have to prove? Number 1, that you disclose the conflict. Yeah, here's my email. That you recommended professional advice. Yes, here's the reference in that email to the recommendation. Ensure that the client's informed consent. Well, that's going to be tough. I'm going to have to make sure that, yeah, it's not just my email going out. I'm going to have to get something back from them, ensuring that they understand what we're doing here. And certainly if they take your recommendation and they seek professional advice, then that's fine, that would work. And then you have to document the client's actual decision in that regard. So what we should have going forward, there's no document now, but I'm assuming that RIA will draft up something, and that is something similar to a Form 127. And I know that everybody in the room knows what a Form 127 is, so I won't go into that in detail. But something along those lines where we would have a form, yes, it's a new form, and we can do that. You could, in fact, take a Form 127 and use it. Now, the other thing is you could also use some kind of email for the disclosure and the recommendation. But then when we get to the third category, which is the evidence that the client understands it, you're not going to be able to use email for that. It may very well be that the client can send you an email and you would appreciate that, yes, they obviously understand it. But there's one more step involved in the process here under this code of ethics that didn't exist with respect to the previous code of ethics. So that's important to be aware of, and that's going to slide over relatively soon in terms of your new obligations. Now, so you're going to require some kind of documentation, and that's going to be before the person actually becomes a client. So make sure that if they're becoming a client, when you show them the property, that they're aware of that fact and they understand that fact ahead of time before, and understand, yes, you know the person who is you may not be the listing agent, but you acted for the person when they bought the property, and you've referred them to their new listing agent, et cetera, et cetera. But you know them quite well. Okay, get that, and that has to take place before they actually become a client. So don't get them to sign up and then say, oh, well, I'm going to try and explain this situation after the fact. No, do it ahead of time. So there's more paperwork with the new code of ethics. Now, in terms of other relationships, do's and don'ts for all registrants, you can engage in mediation, settlement discussions, negotiation, or arbitration in terms of resolving disputes. No problem. That's fine. For brokerages, ensure that every salesperson and broker that the brokerage employs carries out their duties in compliance with this regulation. So that's the obligation in terms of supervision. Now, when it comes to brokers of record, and they have thrown this in now for the first time, ensure that the brokerage complies with this regulation. So this is a compliance obligation on the part of a broker of record, which is now specified in the ethical obligations. Now, when it comes to third parties, don't communicate information to a person who is a client of another registrant unless the other registrant has consented in writing. So not, oh, you can contact them and to explain to them. No, it needs to be in writing. So a lot of this new code of ethics requires paperwork. So if you thought you had a lot of paperwork to this point in time, you have more paperwork going forward starting the 1st of April. Now, when it comes to RICO, there's an actual provision in the ethical obligations here. Don't obstruct or attempt to obstruct any person from making a complaint to the registrar. Obstruct or attempt to obstruct the registrar from making a written request for information with respect to a complaint. Don't obstruct or attempt to obstruct the registrar from receiving accurate and complete information in response to such a request. Induce or attempt to induce a person to withdraw a complaint about the registrant to the registrar. Include a requirement to withdraw or refrain from making a complaint to the registrar in respect to an agreement to resolve a dispute. Well, that's all pretty clear now. And none of that was dealt with in previous provisions with respect to the code of ethics, but we have that now. So if someone is represented by another registrant, then there should be no direct communication with that person. The test here is knew or ought to know, so that the registrant will have to make inquiries right from the outset. So you're going to have to think about it and say, gee, I wonder that relationship, I should pursue that and investigate that ahead of time, and so that I know that person is definitely likely to be represented by that other party. And when it comes to RICO, stay away and stay out of it. That's what RICO is really saying in this new regulation in terms of the code of ethics. You're allowed to make a settlement, no question about it, but the settlement cannot involve any withdrawal of a complaint to RICO. Yeah, you can't do that. You do that, you're going to find yourself in front of RICO going forward. So just the mere fact that you said, yeah, I'll give you the commission back or half the commission as long as you don't proceed with the complaint. Yes, as soon as you've done that, you have committed an offense under the code of ethics, and simply throwing that into normal settlement, which was frequently the case, that's going to compromise things going forward. Now, in terms of what did we have before, we had the old code that was 580, and that was enacted the 31st of March 2006. And the new code, the TRESA code, will come into force on the 1st of April 2023. And then, of course, what we have to be concerned about is, for a period of time, we have the crossover. Okay, we have both situations applying to your set of circumstances. So we have that transition that will take place. And then ultimately, of course, we're going to have going forward just the new code applying. Now, when it comes to the old code, what did we have? And don't think that these are gone completely. And they've simply been reworded in some particular fashion. A registrant shall treat every person the registrant deals with in the course of a trade in real estate fairly, honestly, and with integrity. So there's a couple of things. Now, what it didn't say was courtesy or the politeness business, which is a very Canadian concept. Okay, well, that's what we've got going forward. So then we have inaccurate representations. A registrant shall not knowingly make. Now, interesting situation here. See the word knowingly. That wasn't carried forward. All right, that wasn't what the new act is, or the new code is saying. It didn't say shall not knowingly make an inaccurate representation. So this is being pumped up. And a registrant shall not knowingly make an inaccurate representation about services provided by the registrant. Well, you appreciate that really, the words not knowingly really toned it down in terms of its implications. So the next thing is error, misrepresentation, and fraud. A registrant shall use the registrant's best efforts to prevent error, misrepresentation, fraud, or any unethical practice in respect of a trade in real estate. What did it say? Best efforts. Oh, does it say that in the new act? No reference to, take a good crack at it. It says don't. Period. Don't. Now, unprofessional conduct. A registrant shall not, in the course of trading in real estate, engage in any act or omission that, having regard to all of the circumstances, would reasonably regard it as disgraceful, dishonorable, unprofessional, or unbecoming a registrant. Okay, that was fairly broad, and that's certainly been carried forward, including the aspect of an omission. And abuse and harassment. Registrant shall not abuse or harass any person in the course of trading in real estate. And then, in terms of just being noteworthy, some matters that are not in the new code, they've been transferred to another regulation. And what you'll find is, be sure to look up 567 of 05, okay, which is an older general provision dealing with things that you have to do. And it includes a number of the obligations that you had under the existing code of ethics. So they're not gone. They're just moved over to a different regulation. Now, the important thing to be aware of course, is the fact that there are certain fiduciary duties. What are they? Disclosure, obedience, competence, confidentiality, accounting, and loyalty. And if there were any six things that you should remember, it's those particular duties. Don't be in a position where if you were ever asked that that someone wouldn't you wouldn't be able to respond to that, and you wouldn't know that, and you wouldn't know that off the top. Now, two things, just if you were ever cross-examined, there's two other additional fiduciary obligations that are sometimes expressed. Number one, no conflicts of interest. Well, that comes out of loyalty, and act in the best interest of your client. That's actually competence. All right. So there's six, but you could express them as 8 if you needed to do so. So that's basically it. Thank you very much. And we'll have, I guess, a little bit of time for some questions, if anyone has anything.
Amazing. Brian, thank you for that. Guys, well, let's just let the questions flow. Anyone who'd like, feel free to use your voice, unmute yourself and ask your question. Let's see what we can do with this. If it gets too unruly, I'll put a different process in place.
Hi, Mark and Brian. This is Ashley. Hopefully not cutting anyone else off who was about to ask something. The part about not basically communicating with another agent's client makes it very difficult, just from what I heard here in terms of open houses. When people come to an open house, they sign in, oh yeah, I'm working with so-and-so. That's great. I still want to show them the house. I still have to answer questions honestly, ethically. So to me, that becomes a bit of a tricky thing to navigate, that we can't knowingly say things to, like, I'm not really phrasing this in the way of a question. I'm just sort of making, I guess, a statement, but any advice on how to handle that sort of thing when people come through open houses and they're asking us these great questions that really their realtor should be answering? What's the market value? What will this rent for? You know, how do we, I do often just say, talk to your own realtor about that, but they're putting you on the spot.
Well, I guess it's interesting. I never thought about that in terms of old act, new act. This is the first time it's been presented. And I guess one of the things to reflect on this particular question is, do you know what? We're going to have a whole lot of different areas. So what's important, I think, actually, beyond anything else, is that you ask this question. And I honestly don't know the answer. Of course, there's no cases. This is law that isn't even enforced yet. So when would we know the correct answer to your question? 24 months from now, maybe. That's possible. But, you know, I guess I don't think that the provisions would come in to act unreasonably. So you'd be able to have that conversation with people, but you wouldn't be in a position to provide them with advice or guidance with respect to the market. Oh, yes, this is the time to buy. Yes, this is the perfect time with respect to interest rates. Can you guide them through the house? Absolutely. What you should do is any general questions about the market or interest rates or anything along those lines, you should say, well, you should check with your own agent about that. Or I see that you're dealing with John Smith. Be sure to, speak with John about that. Have John give me a call if you, want to, see the house again, et cetera, with him. Anything along those lines, and then you'd be fine. I would think, reasonably speaking. The difficulty, of course, is you moving into the area where John Smith, reasonably speaking, is the person who should be providing that particular advice. Now, can you answer, sensible questions? oh, I see it's January and there's a swimming pool in the back. Does it work? Oh, yes. Well, we've got some pictures of it, just before they closed it down, and it was closed down professionally. So I think that you can certainly provide any factual information along those lines. So that really shouldn't change going forward. But excellent question, because all of these things are going to be brand new.
Yeah, thank you. It is such a gray area.
We won't know.
Yeah, and we do get asked those questions. What's the market like? Whether they're working with someone or not, everyone's asking every realtor. They want to get 20 different opinions, right? So it's tough for us to not look like idiots saying, well, I can't really discuss that with you. You're working with so-and-so, I can't give an opinion.
Yeah, I'm not sure. I don't know whether there's anybody else that would like to jump in. There's certainly lots of smart people in the room.
Yeah, thank you. I just wanted to throw it out there. Thanks.
I don't think that portion of the act was actually written for open houses. I think we all understand that, yes, you answer questions. I think it was more aimed at realtors not staying in their lane during negotiations and agreements of purchase and sale. Sometimes people just feel that they can pick up the phone to somebody else's client and do a shortcut of, asking the seller, we need to delay the closing, are you okay with that? And they need to understand that they need to go through their actual representative for stuff like that. Too many agents have been wandering out of their own lane.
Brian, I'm going to read Whitney's question, and then we can turn to Rainer, who put his hand up, which is
sure. Okay.
We can apparently do a Zoom, so there we go. So we'll do it from that way. How do we determine public from self-represented at an open house? One says we're supposed to demonstrate reasonable knowledge, skill, etc. The other says we can't provide or encourage them to depend on our knowledge, skills, etc. It's a good question.
Yes. Again, never thought of it. Don't know the answer. But again, I think it's a question of being careful and thinking about it. So the next time you do an open house and there's nobody there, think of some of these different questions and whether they can pop up and be placed in terms of the legal forum as a question. But these are all things that are coming out of this new code of ethics. So the question again is, what I would encourage everyone to do is look at the actual new regulation, start to finish, read it a couple of times today, and go forward with that. I'm absolutely brand new to responding to any of this as well. But I think that one thing is it's not going to be interpreted as being very unreasonable. And so in a sense, effectively, that's Sandra's point. It's going to be reasonable in terms of the application, as opposed to unreasonable in its nature.
Terrific. Okay, Rainer, why don't we do you, then Gina, then Tanmay. Then we'll see if we have any time for any additional questions.
Okay, perfect. Thanks, Mark. Brian, I just wondered, do you have any insight on RIA coming out with the new Form 810 or the Working with a Realtor form to now categorize these 3 new levels of representation?
No, I can't. But what I can say is I hope that whoever wrote the first one isn't the person who's being asked to write the new one.
Okay. Thanks.
Gina, you're up.
Hey, thanks so much for doing this, guys. I really appreciate it. What I find really interesting is that in the Code of Ethics, what has been taken out is in the course of trading in real estate, because that came up quite a bit. And now it has become, just don't do it. So it could encompass a lot of other things in the marketing, in other aspects of, being a realtor and doing our job. So I really like the fact that that was taken out because it kind of opened up a little bit more. Now, is it true that RICO will now be able to go after someone without a complaint being filed?
They could do that anyways. They're not. Their role is not, has not been, restricted to that. But one of the things is it's it looks, and this would be a reflection of the Auditor General's report, which just came out, the end of November of last year. And it would appear that, RICO has had a more of a hands-off role. And one thing that I had noted, which I thought was odd, and that was the most common complaint seems to be breaking and entering into people's houses. And so it's the buyer's agent releases the lockbox code to their own client, and in they go. And it's sort of like, well, that's pretty lazy. Yeah, well, I didn't want to drive, 2 hours across the 401 to show the house because I don't think they're going to buy it anyways. Well, gee, this is kind of crazy. That's what they did. Now, one of the things going back a couple of years ago, and this is when the cap on fines was $25,000. That type of offense actually went up to about 7,500. And there were quite a few that were reported where the fines were actually 7,500. Now, 7,500 when we had a cap of 25,000. Subsequently, we now have a cap of 50,000. And there's all kinds of cases that are reported, all the same thing, and they're $3,500, $4,500, and it's sort of like, well, that's half of what it was. Why is this new? What's this new approach? So I really don't understand the RICO supervision to it, when you know what? All you need to do is suspend this person for a year. Do you know what? And then every agent, all 103,000 agents in the province of Ontario would be aware of that, probably within a week, and they would never, ever, release the lockbox code. Oh, now it's just sort of like, yeah, I can do more business if I am not traveling around doing all these showings. Because what are the chances of me being caught? What are the chances of someone thinking the person who just entered into the house is not a real estate agent? So it's a question of that confrontation. In any event, hopefully RICO's role will be stepped up a little bit, and they'll have a bigger budget for doing this sort of investigation, which would be a good thing, which should also be commensurate with not reducing our fees, when in actual fact, that's exactly what's coming up. Reduced fees this year. Well, keep the same fees and, increase, hire more people to do prosecutions. So I don't know. I mean, that would be, I think, a good thing, but whatever.
All right, 10 May, go for it. Your last question of the day.
Thanks so much, Brian, for this talk. It was really informative. My question is, if we have an unlicensed assistant and there's a violation of the code of ethics from such an assistant, are the realtors liable for those assistants' actions?
Absolutely. So that if you have somebody and you've delegated responsibilities that you have to your to the person working with you or under your supervision and guidance, and they do something incorrect, or they do something that a registrant is required to do, then certainly that's responsibility on the part of the registrant. No question about it.
Thank you.
Perfect.
And
All
in
right,
that
so Brian-
situation, how can you, is there any way to protect yourself rather than?
In that type of situation where you were concerned about your own unlicensed assistant doing something?
Yeah.
I would say that you pretty well have strict liability. That there's really no reasonable way that you can do that. Actually, there is a way. And the way is to get your unlicensed assistant to become a registrant. Now you're not responsible for them. They're doing these things independently, working with you, but independently. They're otherwise on their own.
So if the assistant is registered, then it becomes solely their responsibility and not yours, even if you're supervising them.
Right.
Oh, got it. Thank
Well, no, not necessarily, because you can both be responsible for the same item. But the way of getting rid of some responsibility would be to bump them up, make sure that they're actually registered.
Got it.
All right, Brian. Brian, I'm going to call this to a session to an end, 11:02. We like being punctual. Thank you sincerely. All those who know Brian know that in addition to him generously donating his time to the forum video sessions, Brian is also available to donate his time to anyone who has questions. And I would encourage you to reach out to Brian at any time. He's a wonderful resource. He's a learned man, as you can see. He's always on top of changes, and he is someone who I turn to regularly when I have questions. And I know that I am one of many, many, many who do. So Brian, thank you again for your time. Thank you again for your expertise. And to all of you, thank you for your attendance, Brian, for your own record, because it's hard to see these things. You were up to about 250 people today at max. So it was a great attendance, and we appreciate everyone's time.
Excellent. Thank you. Happy to be here. And this is a group, I think, where everyone wants to stay on top of changes in the law, which is a very good thing.
Wonderful. All right, everyone. Thank you and have a wonderful, profitable 2023. I'll let you know about the next sessions as they take place.